charged with some unspecified general offenses. Principles of legality is a protection of individual persons from being charged with unspecified general offenses. The principles of punishment is based on the concept, three concepts. First concept, criminal law act as a deterrent. Second concept, removes criminal law punishment, move the dangerous criminals from our society, from the populations. Third concept, rehabilitations is an important part of criminal justice systems. Okay, criminal liability. In order to establish the crime, the government must establish two essential elements. Crime requires two essential elements. First element is a guilt act. Second element is a guilty mind. The criminal has a guilty mind and committed the guilty act. The two elements are the requirements of the crime. Guilty act is a physical part, hereby the dependent committed the act, committed the prohibited act, or the dependent committed the omission. Second element is a guilty mind. Guilty mind is a mental part focusing on the dependent's subjective state of mind. Okay. Guilty mind is referred as mens rea. The act is referred as actus reus in the Latin word, or most of the U.S. legal terminology come from the Latin word from the Roman Empire. Okay. First element, act, requirements, prohibit, act, requirements. The act requirements is referred by the Latin name actus reus. Okay. Act requirements require the government to prove that the dependent action objectively satisfying the elements of a particular offense. The wrongdoer must have acted willfully or intentionally or knowingly to be guilty of the crime. That is the actus reus, guilty act. The second essential element is mental elements. Mental element translate literally into the guilty mind. Guilt mind refers to the general requirement that the dependent have a requisite degree of culpability with regard to each element of a given crime. What constitutes the wrongful mental state? Guilt mental state. This guilt mental state are changed. That is according to the actions. For example, criminal lawlessness is a conscious disregard for the justifiable risk. The dependent conscious disregard for the justifiable risk is referred as a criminal lawlessness. The drive, speed too high, but the drive do not care for the car accident. That is referred as a lawless drive. Is a criminal act. Another type is a criminal negligence. Criminal negligence is a deviation from a standard of due care. Everybody has a legal duty to act with the due care. Act with the due care against other people, but some wrongdoing violated this standard. In that case, that wrongdoing will be criminal. Okay. There are some criminal defenses: self-defense, defense, mental incapacity, duress, intoxication. Certain criminal cases require the use of deadly forces. Use of deadly forces is allowed in a case for defeating the another people's attacking against me. That is the self-defense. Mental incapacity is another criminal defense. Dependent action are related to some type of mental disease or defect. I have mental illness. I have therefore, I do not have a sound, legal mind to differentiate the guilty act or guilty mind. That is another type of criminal offense. Dress, intoxicated, is also the criminal offense. I drink alcohol too much, therefore I lost my mind. I do not remember punching against other people. 10-year criminal defenses before the court judge. Crime classifications. There are very big categories of the crime. Felony, misdemeanor, petty offenses. Felony is a crime. Felony is the most severe sanctions. The felony punishment is ranged from more than 1 year in prison, from the more than 1 year of prison to the death penalty is a felony. Normally, crimes are classified based on severity of conduct and punishment. Okay? Felony is the highest severe sanctions. Felony carries the most severe sentence. Misdemeanor is carries less sanctions compared to the felony. Okay? Misdemeanor carries a punishment range punished in the jail less than 1 year. Maximum penalty for the misdemeanor is a maximum up to 1 year jail. Okay? Third category of crime is petty offenses. Petty, small. Okay? The least serious kind of criminal offense is regarded as a petty offense, such as traffic violations, building code violation. These are petty offenses. Okay. Classification of the crime. Most common crime is a property crime. Property crime involves the money, involves the property. Example of property crime are following: burglary, larceny, receive stolen goods, arson, forgery are the example of the property crime. What is the burglary? Burglary is breaking the building and entering the building by force, usually in the night, and steal something or other people's is the burglary, breaking, and entering, unlawful entry, and stealing something is referred as a burglary crime. Larceny crime is a wrongful, fraudulently take the other people's property and carrying away the other people's property is referred as a larceny. What is the arson crime? Arson means intentionally burning of other people's property. Burning. Intentionally burning of other people, of other buildings is referred as arson. Perjury is a fraudulent, made, no writing, the chain, legal right of honor is perjury. Public order crime, most common public order crime includes the public drunkenness, prostitutions, gambling, illegal drug use are the most common public order crime. White-collar crime includes embezzlement, mail and wire fraud, bribery of public officers, bankruptcy fraud, theft of trade secrets, and inside trading are the example of white-collar crime. Embezzlement is a fraudulent appropriation of other people's funds. The embezzlement. Bankruptcy fraud crime to be relieved of oppressive debt. Under bankruptcy law, a debtor has a legal duty to disclose all his or her asset to the public, to the bankruptcy court. However, a debtor fraudulently transfer his or her money to his or family members or to favored parties before or after filing a bankruptcy. That is the bankruptcy fraud crime. The organized crime. The organized crime operates illegitimately to supply illegal goods or illegal services to the other people. Illegal goods such as the marijuana and money laundering is the organized crime. Money laundering is a financial transactions to conceal the identification card, to conceal the source of destination of illegally gained fund is a money laundering. Racketeer, influence, and corrupt Organization Act of 1970 will be discussed in the subsequent slide. Criminal law and business entities. The modern penal code provides the criminal liability for the business. If the criminal act by business entities such as the manager and the president, CFO, okay, the criminal act is within the scope of employment, and the statute imposes liability on the business for such an act, such as the obstructions of the justice or modern penal code provide the criminal liability for the business. If criminal omission is a failure to perform the specific duty that is imposed by the law, such as important disclose only financial report to the investors, the public company must submit the K1 report to the Security Exchange Commissions and the disclose all the company's information to the public, investors. If business omitted that duty, then modern penal code provide the criminal liability for that business. Modern penal code also provides a criminal liability for the business if the crime was authorized by one of the corporation's top level managers, such as the CFO, Chief of Financial Officers, ordering internal documents, internal accountant to file the parts, corporate tax return, to make the parts financial statement. In that cases, modern penal code imposes the criminal liability for that business. Individual liability for the business crime. In 2002, Sarbanes-Oxley Act imposed significant individual criminal liability. Sarbanes from their own money or return to investors from the money paid by subsequent investors, okay, rather than from any actual profit on. The Ponzi schemes are destined to collapse because the earnings, the profit are less than the payment of the investors. Okay? Another. Business crime is a conspiracy is an agreement by two or more persons with a specific intent to commit the criminal act. However, this conspiracy does not require that the action actually be carried out. Do not care. The conspiracy crime do not care the action is actually incurred or not. Only specific intention, conspiration to commit the criminal act between the two or more persons, that is enough to establish the conspiracy crime. Okay. Very, very important business crime is the racketeer influence on corrupt organization act, RICO. RICO stands for Racketeer Influence and Corrupt Organization Act. Federal statute. RICO is a federal statute that makes is a criminal offense for any persons who is associated with an enterprise, associated with the business to conduct or to participate in its affairs through the pattern of racketeering activity. What is the racketeer? What is the meaning of a racketeer? Racketeer is somebody who makes money from illegal activities. Prostitute is a racketeer. Directing the people is a racketeer. Selling the worthless goods, selling immoral goods, and selling illegal goods, such as the marijuana. Selling the marijuana is a racketeer, merchant. Doing a business or obtaining a gain from prohibited activities is a crime under the RICO Act. This is a business crime. Another business crime is insider trading, security, and exchange Commission Act of 1933 and 1934, and the insider trading and security fraud and enforcement act prohibit the inside trading. These two laws prohibit corporate insiders who have access to certain information that is not available to the general ordinary people, not available to the general investment public, from trading their companies, common stock, selling and buying the common stock based on the inside knowledge. This act, rape, SAG Act, and inside trading security fraud enforcement act raised tough criminal penalties, tough civil penalties for inside trading and wrongful of their employees of brokerage houses. Another business crime is bribery. Bribery involves the scheme to pay a government officers, the money, to give the money to the government officers in order to obtain the favorable treatment for the personal transactions, for the business transactions. That is the bribery crime. Remember that bribery is an offense, criminal offense, that requires only the offer, the money, offer of the bribe. Bribery is not necessary that the transaction actually took place. Do not care that actually give the money to the public officer. Okay? Okay, another business crime is obstructions of the justice. Obstruction of justice is an act committed with the willful intent to obstruct the legislative process, obstruct judicial process. That is the obstruction of justice crime. It is designed to protect the integrity of legislative proceedings or judicial proceedings. Example of the obstruction of justice includes the lying to investigators, cleaning up files, changing the record of a phone conversation, and shredding, altering documents during pending investigation is the example of the obstruction of justice crime. Okay, another business crime is a Foreign Corrupt Practice Act. Foreign Corrupt Practice Act of 1977 is a criminal statute that was enacted to prevent corporate bribery of foreign officers, foreign countries, public officers in the business transactions. Okay, next topic. Criminal justice system. Criminal justice system is the best sort of as a one process that operates in two phases: investigation phases, adjudication phases. Investigation phases. The authorities, the government authorities, become aware of an illegal criminal act and begin investigations. Who is the government authorities? Policeman, detective, prosecutor. Okay? This authority begin investigations by gathering the physical evidence, and investigations by interviewing the witnesses, and investigations by interviewing witness and the potential suspect, interviewing the potential suspect, and obtain such warranty. Such warranty will be issued by the court or will be issued by the grand jury. Once the government authorities believe that the sufficient evidence create enough probable causes. Probable causes, very, very important terminology in the criminal law and the criminal procedure. The government must create enough evidence in order to create the probable causes. They will either obtain, in that cases, the government, the policeman detective will obtain arrest warrant or arrest. Policemen arrest the suspect people by taking him into the jail, into physical custody in the police office. Okay, this investigation usually based on the probable causes. Probable cause is a reasonable grounds for making the search, making the charge, making the arrest, making him into the physical custody. Adjudication phases. If the prosecutor elects to proceed with the charge, the defendant is entitled to preliminary adjudications. The jurisdictions, the 50 state has 50 jurisdictions of the criminal law. Okay, jurisdictions use either grand jury, some jurisdictions, some states use the grand jury system. Some states use the preliminary hearing with the magistrate system. Preliminary hearing is sometimes referred as a probable cause hearing. Okay, grand jury, Fifth Amendment of U.S. Constitutions established a grand jury, provide a grand jury system. A grand jury consists of the 23 U.S. citizens. Before anyone can be tried for crime, there must be a presentation or indictment by the grand jury. Grand jury have legal right to determine the probable causes, the standard of probable causes. Is that grand jury believes that the crime has been committed in conjunction with the preponderance of the evidence. Also, grand jury has a power to issue the subpoena. That is referred as a subpoena power. Subpoena is a writ issued by the court to compare the testimony by the witness or by the production of the evidence under the penalty for the failure. Okay, there are 6 steps for adjudications in a criminal cases. First step, preliminary hearing. The prosecutor must introduce enough evidence in order to show the probable causes that the accused committed a felony. Step 2, the indictment. The prosecutor filed the indictment or draft charge due to the insufficient evidence. Step 3, dependent enter the plea. There are 3 types of plea. I'll tell you in subsequent slide. Step 4, if no plea bargaining is reached, if no plea agreement is reached, dependent goes directly to the trial. Step 5, conviction of the dependent or accuser of the dependent. Last step, if a criminal is convicted, the judge will give the sentences. Okay. 3 types of pleas in a criminal cases. The dependent has 3 possible pleas to enter the criminal cases for avoiding the cost of the trial and the cost of subsequent civil actions. Why dependent pleas? Because criminal convictions may be the basis for the subsequent civil damaged suit. If not plea and have a penalty, in that case, it's a natural step. The dependent will compensate a lot of money to the plaintiff. Therefore, normally, the criminals want to plead. Okay? There are 3 types of plea: guilty plea, not guilty plea, nulla condemned plea. What is the meaning of nulla contemptor? No contest. I do not wish to contend. Okay? Computer okay. Constitutional protections. The Bill of Rights of U.S. Constitution, the 18 articles of U.S. Constitution is called as a Bill of Rights. This Bill of Rights provide the civil liberties that protect the persons from the power of the government, regulating the government power, including the persons accused of crime. The constitutions also protect the business from excessive government regulations. Such an arrest, the First Amendment of U.S. Constitutions protect individual persons from unreasonable search and unreasonable seizures. A warrant is usually required before the search takes place, with certain exceptions. Plain view exceptions, pursue exceptions. Okay? The probable causes is a reasonable ground for believing such should be conducted, must be conducted, or person should be arrested by the policeman. To issue the search warrant, the policeman must be convinced that there is a probable cause to believe that the search of the criminals will reveal a specific illegality based on the evidences that would convince the reasonable person the search is more likely justified than not. Expectation of privacy requires the authority, government authority, to obtain the warrant issued by the grand jury before searching the areas where the citizens has a reasonable expectation of the privacy. Okay? The First Amendment to the U.S. Constitution protect the individual. Everybody has a fundamental legal right to have privacy. Okay? That privacy cannot be violated under the Fourth Amendment. Plain view doctrine. Plain view doctrine allows the policeman to seize without the warrant. Without the warrant, the policeman detected, seized the evidence or seized the contraband that are found in the plain view during a lawful observations. Anything the policeman can see with his or her naked eye or basic equipment that is available to the public will be considered in plain view. The thief steal and run away in the sight of the policeman. In that case, the policeman can seize and arrest that criminals without the warrant under the plain view doctrine. Okay, such of the business premises. The court reluctant, the judge reluctant to extend the reasonable expectation of privacy right to the workplaces. Okay, because the business is highly regulated. Okay. Self-incriminations. The Fifth Amendment to the U.S. Constitution provided that no person shall be compelled in any criminal cases to be a witness against himself. Therefore, the policeman must give the warrant, the Miranda and Miranda warnings to the criminals before arresting him or her. Okay. This is a very Miranda versus Arizona is a landmark case for the criminal procedure. Okay. See this anyhow. Okay. Professional business record. This case, read this case anyhow. Try. The Sixth Amendment provides that all criminal prosecutors, all criminal prosecutors have a legal right to enjoy the right of the speedy trial. We're almost done. Arrest and criminal process, arrest and booking defendant before a warrant. Okay. See this slide anyhow. Okay. Before warrant for arrest can be issued, the power of the court must be registered for believing that the individual has committed a crime. There are two types of indictment. Indictment information. Indictment is issued by grand jury. Information is issued by prosecutor. Exclusionary rule. Trial courts are required to exclude